The son who never asked for anything almost lost everything to the son who never stopped asking, until a $1 real estate transfer showed up in public records. I've been lurking on this subreddit for years, reading stories that made me think, that can't possibly be real. The ones where family members expose themselves as strangers you never actually knew. The ones where a parent you loved turns out to have been running a parallel life of favoritism so deep it rewrote your entire childhood in retrospect. I'm not lurking anymore. My name is Daniel. I'm 39. I'm a high school history teacher in Columbus, Ohio. I drive a 2016 Honda Accord with 94,000 miles on it. I coach junior varsity baseball on weekends, and until 6 weeks ago, I thought my family was difficult but fundamentally intact. I thought my mother loved both her sons. I thought the apartment on Maple Ridge Avenue, the one my father worked himself into an early grave to pay off, was a shared inheritance. I was wrong about all three of those things. This is the story of how I found out, what I did about it, and what happened when 72 hours turned out to be enough time to change everything. Background: the family you think you know. My father, Robert, died in 2021 after a brief and brutal fight with pancreatic cancer. He was 68. He was the kind of man who fixed his neighbor's gutters without being asked and remembered the names of every kid on my baseball roster. He worked as a machinist for 31 years, lived below his means, and paid off the two-bedroom apartment on Maple Ridge outright in 2018. It was worth about $195,000 at the time. In today's Columbus market, it's closer to $240,000. My mother, Patricia, Pat to everyone who loves her, is 66. She is not a villain in the way villains usually appear. She doesn't twirl a metaphorical mustache. She's soft-spoken, she makes excellent brisket, and she cries at pharmaceutical commercials. But she has, for my entire life, operated according to a logic I could never fully decode. My younger brother, Marcus, was the one who needed protecting. Marcus was sensitive. Marcus had a hard time. Marcus struggled. Marcus is 34. Marcus has struggled, specifically, with holding a job for longer than 18 months, maintaining a relationship without manufacturing a crisis, and existing in a room without eventually redirecting every conversation back to himself. He is charming in the way that car salesmen who've been in the business too long are charming, fluent, slightly rehearsed, aware of exactly how much eye contact to make. I spent years telling myself I was being uncharitable. Marcus had anxiety. Marcus had a rough patch in his mid-20s. Marcus was trying. What Marcus was actually doing, I now understand, was cultivating my mother's guilt like a garden. Watering it with just enough crisis to keep her engaged. Pruning away anything, including me, that suggested she didn't need to keep rescuing him. When my father died, Marcus moved back into the Maple Ridge apartment, temporarily, to help Mom through her grief. That was 3 years ago. He still lives there. He pays no rent. He contributes nothing to utilities. My mother has told me, on multiple occasions, that she doesn't mind because Marcus is just getting on his feet. Marcus, in those 3 years, has started and abandoned a dropshipping business, a podcast about financial freedom, and a brief but expensive foray into cryptocurrency day trading, the losses from which my mother quietly covered. I have never asked my mother for money. I want to say that not for points, but because it matters to the story. I bought my own first car, paid my own way through Ohio State on loans I finished paying off at 35, and when my furnace died 2 winters ago, I spent a week in a down jacket in my own house rather than tell her because I didn't want her to worry. I am telling you this so you understand that what happened was not ambiguous. It was not a misunderstanding born from a mother trying to be fair. It was a deliberate, secret transaction designed to lock one son out of his inheritance before the other could object. The discovery. I found out on a Tuesday. My mother had called me the week prior, which was not unusual. She called every Sunday and sometimes midweek, and our conversations were pleasant in the way that conversations become pleasant when two people have quietly agreed not to discuss the things that actually matter. I told her about my students. She told me about her book club. She did not tell me she had recently signed a quitclaim deed transferring the Maple Ridge apartment to Marcus for $1. I found out from a property records search. Here is how that happened. I was helping a colleague at school, a woman named Carrie who was going through a divorce and needed help understanding how to look up her husband's real estate holdings. I walked her through the Franklin County Auditor's website, showed her how the property search worked, how you could look up any address or owner name and pull transfer history, deed records, everything. It takes about 4 minutes and it's all public record. On a whim, the kind of whim that your gut has been preparing you for without telling your brain, I typed in my mother's name. The Maple Ridge apartment appeared. And next to it, under current owner, was Marcus Ellison. Transfer date, 11 weeks prior. Consideration, $1. I sat at my desk for a long time after that. long enough that Carrie asked if I was all right. I told her I was fine. I drove home in something that wasn't quite anger yet. It was more like the feeling you get when you're reading a novel and you suddenly realize you've been misunderstanding a character for 200 pages and now you have to go back and reread everything through a different lens. By the time I got home, it had become anger. The 72-hour window. I did not call my mother that night. I did not call Marcus either, though I drafted approximately 11 different versions of a text message, each of which I deleted before sending because I understood, even in that first raw hour, that the worst thing I could do was let either of them know I knew. Not yet. What I did instead was call my friend Todd, who is a paralegal at a real estate law firm in downtown Columbus. I told him what I'd found. He asked me 3 questions in quick succession. When did your father die? Was there a will? And do you have access to any documents from before the transfer? The will, it turned out, was the problem. My father had a will. I'd been present when he signed it, 2 weeks before he died, in a hospital room that smelled like antiseptic and grief. That will, which I had a copy of, left the apartment to my mother for the duration of her life, with equal shares to both sons upon her death. It was a life estate with remainder interest. It was, as Todd explained to me, not a document that had been properly accounted for in this transaction. But here was the complication. The will had gone through probate in 2021. The apartment had been transferred to my mother's name cleanly. She was the legal owner. And as the legal owner, she had the right to transfer it to whomever she wished. Unless... Todd asked me the question that changed everything. Do you have a copy of the promissory note your father signed when he paid off the mortgage? Or any financing documents from when he bought the place? I did not. But I knew where they might be. In 2019, my father had refinanced the apartment briefly to cover a medical expense, my mother's knee surgery, which insurance had covered only partially. I remembered this because I had been there when he signed the papers, and I remembered him showing me a document afterward, a notarized statement that he'd asked both Marcus and me to keep copies of. It was a statement of intent, informal, not a legal instrument in itself, but signed, notarized, and dated, saying that the Maple Ridge apartment was intended as a joint inheritance for both sons, regardless of any future transfer or title change. He had given me that document. It was in a manila folder in my filing cabinet, under Dad Estate. I found it in 11 minutes. Signed by Robert Ellison. Notarized by a woman named Beverly Gross at a UPS store on Henderson Road. Dated March 4, 2019. It wasn't a deed. It wasn't a will codicil. But Todd, when I photographed it and sent it over, went quiet for a long moment and then said, "Okay. This isn't nothing. This might actually be something. How long until Marcus closes a sale?" That was when I found the Zillow listing. Marcus had listed the apartment 3 days after the transfer. The listing had gone live 5 weeks ago. It currently showed as under contract. I found, through a little more research I'm not entirely proud of, that the projected closing date was in 5 days. I had approximately 72 hours before my brother sold an apartment that was half mine, pocketed $240,000, and disappeared into whatever version of getting on his feet he was planning to fund with my father's life's work. I did not sleep that night. Update 1, hours 0 to 24, building the case. The next morning, I took a personal day from school, the first I'd taken in 2 years, and drove to Todd's office. Todd introduced me to a supervising attorney, a woman named Sandra Okafor, who specialized in real estate disputes and elder law. She was in her mid-50s, wore reading glasses on a beaded chain, and had the particular calm of someone who had heard every version of every family catastrophe and found all of them both predictable and solvable. She reviewed the notarized statement from 2019, the will, the probate records, the current deed transfer, and the Zillow listing, and then she folded her hands on her desk and said, "The 2019 document isn't a deed, but it's a written, notarized statement of intent by the title holder, establishing a third-party interest. Combined with the will's original language about remainder interest, we have grounds to argue that your mother's transfer to your brother was made without accounting for a pre-existing equitable claim. It's not bulletproof, but it's enough to file for a temporary restraining order to halt the sale." "How long does that take?" I asked. "If we file today, we can request an emergency TRO hearing for tomorrow morning. Judges don't love real estate disputes, but they take fraud-adjacent elder transactions seriously, especially when there's a documented history of undue influence." I asked her what she meant by undue influence. She said, "Your brother has lived in the apartment rent-free for 3 years. He moved in under the pretense of supporting your grieving mother. He is the primary person in daily contact with her. And this transfer happened with no attorney present, no independent legal counsel for your mother, and no notice to the co-inheriting party. That pattern, isolation, dependency, secret transaction, is textbook undue influence in an elder law context. I signed the retainer that afternoon. Sandra's associate began drafting the TRO application while I drove home and spent 3 hours compiling everything I had: the 2019 document, scanned copies of the original will, a written timeline of Marcus's residency, a screenshot of the Zillow listing with its close date, and a carefully written declaration of the facts as I knew them. At no point during those 24 hours did I contact my mother or Marcus. At no point did I hesitate. Update 2, hours 24 to 48, the hearing. The emergency TRO hearing was held at 9:15 a.m. in Franklin County Common Pleas Court. Marcus was not there. He hadn't been served yet. Notice in emergency TRO situations is imperfect, and Sandra had advised me that he likely wouldn't appear at this stage. The buyer's agent, however, had apparently received some kind of informal notice, because when I arrived at the courthouse, Sandra told me that the buyer's attorney had called her that morning asking what was happening. The judge was a man named Judge Carroll, who was perhaps 60, with the expression of someone who had eaten too many lunches at his desk. Sandra presented the case concisely: documented statement of testamentary intent from the deceased title holder, notarized in 2019, probated will establishing remainder interest for both sons, transfer made for nominal consideration to one son without independent counsel or notice to the other, active sale proceeding toward close within 72 hours. The judge asked 2 questions. First, was the mother, Patricia Ellison, competent at the time of the transfer? Sandra said we were not alleging incompetence, but rather undue influence through extended cohabitation and financial dependency. Second, had the brother been served? Sandra said service was being completed that morning. Judge Carroll granted the temporary restraining order. The Maple Ridge apartment sale was frozen pending a full hearing in 15 days. I sat in the car outside the courthouse for about 10 minutes before I could drive. Not because I was happy. I wasn't happy. I was something past tired, in the specific way you get tired when you've been braced for impact for so long that the moment of collision is almost a relief. My phone showed 3 missed calls from Marcus. He'd been served. Update 3, the conversations. I did not return Marcus's calls that day. I called my mother. I had rehearsed this conversation in my head so many times over the preceding 48 hours that I'd worried I would deliver it like a monologue, stiff and over-prepared. But when she picked up and said, "Danny," in the voice she uses when she already knows something is wrong, all the rehearsed language fell away. "Mom," I said, "I know about the apartment." There was a long silence. Long enough that I thought for a moment the call had dropped. "I was going to tell you," she said finally. "When?" Another silence. Marcus said it would be better to wait until everything was settled. I took a breath. I had promised myself I would not yell. I had promised myself I would be measured, because being measured was both the right thing and the strategic thing, because any judge who later reviewed the situation would be looking for evidence of who in this family operated with integrity under pressure. "Mom," I said, "I need to understand something. Not about Marcus. About you. Did you know what was in Dad's will? Did you know what he wanted?" She said yes. She said it very quietly. "He wanted us both to have it," I said. "He told me that. He signed a document saying it. He died believing that's what would happen." What followed was not an argument. It was more like a slow, painful unpacking. My mother told me that Marcus had come to her 6 months ago saying he had found a financial opportunity, a real estate investment that required capital, that he needed the apartment either as collateral or to sell, that he had explained it to her as a temporary measure, that he had told her, specifically, that he would share the proceeds with me. "Has he shared anything with you yet?" I asked. Silence. "He said when it closes." "Mom." I kept my voice even. "The sale is frozen. I filed for a restraining order. There's going to be a hearing in 15 days. I need you to know that I'm not doing this to hurt you. I'm doing this because Dad signed a document in 2019 that said this apartment belongs to both of us, and I'm not going to let that be erased without at least having a judge look at it." She was crying by the end of the call. I did not apologize. I told her I loved her. I told her I would talk to her more when she was ready. I heard from Marcus by text at 9:45 that night. The message was 4 paragraphs long. It described me as jealous, vindictive, and selfish. It said I was attacking our mother. It said the apartment was legitimately transferred, and that any judge would see that. It said I had always resented his relationship with her. I forwarded the text to Sandra and went to bed. Marcus called twice more that night and once the following morning. I didn't answer. Sandra had advised me clearly. All communication went through her. What I did not know, until Sandra called me 2 days later, was that Marcus had done something revealing in the hours after receiving the TRO notice. He had called the buyer's agent and attempted to renegotiate a faster close, proposing a cash-only arrangement at a reduced price, $210,000 instead of $238,000, to see if the deal could be completed before the hearing. The buyer's agent, to his considerable credit, had declined. He had also mentioned this to his own attorney, who had mentioned it to Sandra. In elder law and undue influence cases, attempting to accelerate a transaction after receiving legal notice is exactly the kind of behavior that makes judges very, very unhappy. Update 4. The 15 days. The period between the TRO and the full hearing was the strangest stretch of my adult life. I kept teaching. I kept coaching. My students didn't know. My players didn't know. I stood at a whiteboard and talked about the Missouri Compromise, and the afternoon light came through the windows the way it always does, and everything looked completely normal from the outside. Sandra worked methodically. She requested financial records from my mother's bank, obtained with my mother's cooperation, which surprised me, and found that over the past 3 years, Marcus had made 11 separate requests for transfers from her savings account, totaling $41,300. Each one had a stated purpose: rent deposit for a new apartment he never moved into, medical expense that didn't match any insurance record, a car repair that happened on a vehicle he'd sold 9 months prior. None of this money had been repaid. Sandra also located the buyer, a property investor named Greg Hartwell, who, when deposed in an informal capacity, confirmed that Marcus had approached him unsolicited through a real estate wholesaling platform and had initially represented himself as the sole heir of the property. Sole heir. Sandra used that phrase in her filing like a chisel. On day 9 of the 15, my mother called me. Not crying this time. Something different in her voice, the flatness that comes after crying when the feelings have exhausted themselves into clarity. She told me she had spoken to an attorney of her own, that she had been in contact with Sandra's office, that she wanted to provide a declaration to the court. About what? I asked. About what Marcus told me, she said. About what he told me you'd agreed to. About what he said about the money. She paused. He told me you knew about the transfer. He said you'd already agreed to it. He showed me a text message. Mom, I never agreed to anything. I didn't know until I looked it up. I know, she said. That's why I'm calling. She submitted a declaration 3 days before the hearing. It laid out, in her own words, the sequence of events, Marcus's approach, his representations, his assurances, and the specific false claim that I had already consented to the transfer. It also confirmed that she had not had independent legal counsel at the time of signing the quitclaim deed. Marcus's attorney, upon receiving the declaration, filed a motion to delay the hearing. Judge Carroll denied it in less than 4 hours. Update 5. The hearing. The hearing lasted 2 hours and 40 minutes. Marcus arrived with an attorney who had the aggressive posture of someone billing by urgency. He sat across the courtroom from me and did not make eye contact once, which was notable because Marcus has always deployed eye contact like a tool, that particular steady, earnest gaze that says, I'm the reasonable one here. Sandra presented the case in 4 parts. The 2019 notarized document establishing testamentary intent. The will's remainder interest language. The pattern of financial transfers establishing a dependency relationship. And the false representation made to Patricia Ellison that her older son had consented to the transfer. Marcus's attorney argued that the quitclaim deed was valid, that Patricia was competent, that the 2019 document was not legally binding, and that I was attempting to override my mother's free choice about her own property. Judge Carroll asked my mother directly. She had come to the hearing, which I had not expected, whether she had been told I had consented to the transfer. She said yes, and that she had since learned this was false. He asked Marcus's attorney whether his client disputed that representation. Marcus's attorney said his client had no specific recollection of making that statement. Judge Carroll looked at him for a long, quiet moment. His ruling came 8 days later, delivered in a written opinion that Sandra read to me over the phone. The quitclaim deed was voided. Specifically, Judge Carroll found that the transfer had been made under circumstances consistent with undue influence, extended cohabitation, financial dependency, isolation as primary family contact, no independent counsel, and a material misrepresentation made to the grantor at the time of transfer. The 2019 document, while not legally binding as a deed or codicil, was sufficient evidence of the decedent's intent to establish an equitable claim on behalf of the petitioner. The apartment reverted to Patricia Ellison's name. The sale to Greg Hartwell, who had already found another property and withdrew without objection, was dissolved. Sandra also filed a separate action regarding the $41,300 in transfers from my mother's accounts. That case is pending. I'll update when there's more. Aftermath. Marcus has not spoken to me since the hearing. I'm told by my aunt, my father's sister Carol, who has been a quiet ally throughout this, that he is furious and considers what I did a betrayal. I find this framing too exhausting to engage with directly. My mother and I have had 3 conversations since the ruling. They have been careful, searching conversations. She apologized to me. I accepted it, because I believe it was genuine, and because she is 66 and lost her husband and has been alone with a son who is very good at making himself appear indispensable. Understanding why something happened doesn't erase the wound, but it helps with the infection. She has retained her own elder law attorney, not Sandra, but someone Sandra recommended, to review her financial situation and create a formal estate plan that is documented, witnessed, and not susceptible to private renegotiation. The apartment is being managed by a professional property management company. My mother receives the rental income. Marcus has moved out. As of this writing, he is living with a friend in Dayton and, as far as I know, workshopping a new business idea. I still teach. I still coach. Last Saturday my team won a game they had no business winning, on a 2-out single in the bottom of the 7th, and I stood in the dugout afterward and felt, for the first time in 6 weeks, like myself. What I want to say to anyone reading this: if you're in a family that has a protected one, the sibling who always gets the benefit of the doubt, who is always the one who needed the help, who operates in the space between your parents' love and their anxiety, I want to tell you something directly. You are not being uncharitable. You are not jealous. You are not the villain for noticing. But notice quietly. Document everything. Build your case before you announce it. The instinct when you're hurt is to confront, to demand, to make the other person acknowledge what they've done. That instinct will lose you the apartment and cost you the court case. My father signed a document in 2019 at a UPS store on Henderson Road because he knew his family was complicated and he wanted to protect what he'd built. He didn't live to see whether it would matter. But he signed it, and he gave me a copy, and I kept it in a manila folder under Dad, Estate, and when I needed it, it was there. Keep the documents. Keep the documents. TLDR, my mother secretly transferred my deceased father's apartment to my younger brother, who had already listed it for sale. I had 72 hours, a notarized document from 2019, and a very good attorney. The deed was voided. The sale was stopped. My brother, who misrepresented my consent to my own mother, is now explaining himself in an ongoing financial dispute. My father's apartment is still in the family. Edited to add, several people have asked about the attorney. Sandra Okafor practices in Columbus, and I'm not going to post her contact information here, but if you're in Ohio and dealing with an elder law real estate issue, search for attorneys who practice at the intersection of real estate law and undue influence. That's the specific expertise you need. A general estate attorney may not have the litigation background for this. Second edit. I'm not reconciling with Marcus. That question has come up a lot. I genuinely don't know what my mother will do, and that's her choice to make. But I have no roadmap for a relationship with someone who told my mother I'd consented to something I had no knowledge of, who tried to sell my father's apartment while I was teaching 6th period history 20 miles away. Some bridges have load limits. This one crossed them.